Welcome to Limits Exhausted, Texas's personal injury litigation podcast.
Hey everyone, welcome into an all-new episode of Limits Exhausted, Texas Injury Litigation Podcast with attorney Kiernan McAlpine, the founder over at McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. I'm your host, Mike Leon. Kiernan has tried more than 40 cases to verdict, and he's known for handling complex, high-value litigation involving 18-wheelers, catastrophic injuries, and wrongful death. And in today's episode, we're going to be talking about specifically the insurance playbook, the strategies and pressure points insurers really rely on behind the scenes, and why understanding those tactics are really essential for the attorneys that are handling these serious injury cases. Kiernan, it's good to see you as always. When attorneys talk with you about these difficult cases, like I mentioned, that you've handled, what's the most fundamental misunderstanding that some people have about how insurance companies actually evaluate serious injury claims?
Thanks for having me, Mike. I think the biggest potential area of misunderstanding for how these cases work on the insurance side is how big of a difference there is between the way that a small case is handled by insurance and the way a bigger case is handled by insurance. A smaller case, especially if it's in pre-litigation, is going to be handled by the adjuster, essentially riding solo. The insurance adjuster in a smaller case is going to have a certain amount of desk authority, which means, like, for example, if it's a $30,000 minimum policy in Texas, the insurance adjuster will probably have authority between $20,000 to $30,000 that they can offer to settle a case without having to go to a superior and get permission to settle for that amount. So a smaller case insurance adjuster, their job is to try to settle the case within their desk authority as inexpensively as they can, so that anybody who might be looking over their shoulder later on doesn't think that they've made any mistakes. But their job is to try to get the case done without having to go to anybody else in order to try to get more authority than what they've already been given as their desk authority. Right. Now, on a bigger case, generally there's going to be a litigation adjuster in a bigger case because those cases typically have to be litigated. What we see is, yes, there is an adjuster that is assigned to the case, and they'll be working with the defense attorney, but that adjuster is not going to have desk authority on a minimum $1 million policy case. That adjuster is not going to have desk authority for the policy limits of $1 million. They're not going to have anywhere close to that. In order for them to actually get authority to settle a case, they're going to have to go to a manager, potentially do a committee, have a roundtable discussion about the case, and it takes time for a bigger case for the defense to come up with anywhere close to a fair and reasonable number to settle the case, which is why bigger cases can often seem slower and frankly dumber than smaller cases, because nobody wants to pay too quickly. It looks like panicking, potentially could be audited later. So just generally speaking, what you got to know is that in a smaller case, you're negotiating numbers, but in a bigger case, you're negotiating risk. And it's a very different approach that goes into it.
Yeah. Are there any early signs within that case, whether it be small or a large one, that kind of gives you an early read on how aggressive the carrier is going to be?
Absolutely. So two different things I want to mention here. The first one is that if the case is in a pre-litigation, like if lawsuit hasn't been filed yet, one of the signs, and this is pretty counterintuitive, but one of the signs that the insurance company has an aggressive attitude towards the case is a lot of phone calling, okay? So if the adjuster on a case is making a lot of phone calls, not returning phone calls that the client placed or that I placed, but if they're making a lot of phone calls to try to get the claimant, the victim on the phone, to talk to them, to give a recorded statement, to just talk to them about the case, usually that's a sign that they are going to try to defend heavily against the case, undervalue or lowball the case. You might think, if you're a victim of one of these accidents and you have injuries, that the insurance adjuster calling you a lot is a sign that they're paying attention to the case. They're keeping you in the loop, keeping you informed, paying attention. No, it's usually the opposite. It's usually that they're trying to get you to say something on the phone that they can use later to try to minimize the case. Now, when it comes to litigation, one of the biggest tells as far as what the insurance company's ultimate attitude is going to be on the case is who they hire as defense counsel. So there are a lot of different defense attorneys, and there's different styles of defense attorneys, different defense firms with different cultures. And if, a adjuster goes and hires a, bulldog gung ho firm that's, known for being very anti-plaintiff, never come across a plaintiff who they thought was credible, tries a lot of cases, takes a very aggressive stance within those cases, it says a lot about what that insurance adjuster's attitude is towards the case. And if they're going to hire a different person in a case where they think they have big exposure than in cases where they don't. They don't always get it right, not by a long shot, but who the insurance company winds up hiring as their defense counsel does tell us a lot about how they're looking at it.
Yeah. Let me ask you something else that they're going to be looking at, which is, these document requests, the medical reviews. From your experience, how or do insurance use delays and all of these things that I mentioned to influence case value before the trial even becomes, like a possibility?
Sure, absolutely, Mike. So one thing is that discovery isn't just a way to manufacture delay. I mean, discovery is extremely important. We really can learn a lot about a case during discovery that we didn't know before the lawsuit was filed. So discovery, yes, can be and has been abused badly, and it can be used as a delay tactic, but it isn't necessarily. So when we get a read on whether a defendant, their counsel, is using discovery to find out information or using it to harass or delay, that tells us a whole lot. Now, in terms of the medical reviews, I mean, I could pretty much write you one of these medical reviews from one of these, doctors that they frequently hire to, minimize harms and losses. I mean, there's a very defined toolbox of different things that they could use, and they get different tools at different times. And sometimes they get the wrong tool, at least in my opinion. But it's very, very unusual for us to see a case where they're inventing a new tool to defend against the case. Like, we see the same stuff over and over again. So how they're defending it, what tool they're getting out of the toolbox tells us a lot about how they're going to be trying the case. And it creates opportunities for us, because when they get the wrong tool for the wrong job, it can really cost them later.
Yeah. Kiernan, you mentioned the opposing counsel and stuff like that. How do patterns like that, like the reputation of, the other counsel, venue considerations, or even prior verdicts, like how does that kind of factor into the way the carrier sometimes positions themselves?
Sure. I mean, a lawyer, this is almost a proverb at this point, but as a lawyer, your reputation is your number one asset. It's the most important part of your career. And the way that you're perceived by the other side is a very, very important factor in cases. And it happens a lot through defense counsel. Like, if you've got one of these, bulldog aggressive, they're probably telling their carrier that they can win the case at trial, and they're going to write a report to the adjuster that's through rose-colored glasses from the defense side, and your reputation may not have as much of an impact on them. But that's also not necessarily the kind of lawyer that we see getting hired in cases that have a ton of exposure. I mean, they're going to hire counsel in cases that have a ton of exposure, that are more professional and like less offensive and less aggressive. And they'll show up in trial and they'll try to get the jury to like them so that they can use that to kind of leverage that into a more favorable verdict for their client. But those are also the kind of lawyers that will trade on opposing counsel's reputation. If they know that the case is more likely to be tried because of who the lawyer is, because they're not going to recommend that their clients settle for less than fair value, it's a lot more likely that they're going to be reporting that to the insurance adjuster, and they're going to be telling them that this isn't a case where you can just discount on, you can just heavily discount off fair value, and at the end of the day, they'll take it because they don't want to try it. And also mediators, a lot of cases go to mediation. A lot of courts are going to require a mediation before a case can be tried. The mediator will typically know the attorney's reputation, will be able to use that in the other room with defense counsel, with the adjuster, defense decision maker, and they'll be able to kind of help them understand that this is a case where they need to be, offering their full evaluation of the case rather than one where they can just continue to fish for a discount.
So, Kiernan, can you walk us through a past case without obviously getting into the specifics where maybe one of these insurance tactics backfired because there was a little bit of a deeper investigation, or even one of those so-called experts that you mentioned revealed something that the carrier truly wanted to stay hidden?
Sure. Yeah. I'll tell you about one of the very first big cases that I handled about 12 years ago, where there was my client, the victim of the crash, was driving a box truck, and he got smoked by an 8 Series BMW late at night. And we filed the lawsuit. The client had a surgery. It was a pretty big case. We served discovery requests, and we got a lot of weird objections, more than normal things we weren't expecting. And the questions that they answered seemed to heavily rely on, I don't recall, I don't remember, I don't know for sure, sort of a hazy memory type situation. So we took the guy's deposition that hit the client, and we were getting, way more I don't recalls and I'm not sures than what we're usually accustomed to seeing. It's often the case that witnesses will lean on lack of memory or difficulties with their memory is kind of a safe spot for them to retreat to. But this guy was doing it way more than I was expecting, or way more than I would consider to be normal. So it gave us a little bit of a clue that there was something going on with the case. And what ultimately ended up happening was we had to file motions with the court to compel certain discovery. And what we ultimately got was a bill from the restaurant Uchi. It's a pretty famous restaurant from Austin. There's locations in Houston and some other places as well. This guy had about a $400 bar tab from Uchi that we ultimately discovered, which was pretty strong evidence in the case. It gave us a pretty good insight into why the guy wasn't able to remember a lot of the things that we were expecting him to. And that was something that we had to push pretty hard for through discovery, but it ultimately kind of broke the case open. And it was one of the biggest settlements that I got earlier in my career.
Okay, a $400 bar tab, and someone can't give the information. That's really interesting. So, let me ask you, staying on that, because you mentioned these are high exposure cases, some of the ones that you've handled. What other pressure points actually move the negotiations outside of like an example like you just gave, finding out about that? But like, what are some other pressure points that actually move the negotiations?
I mean, one thing I'm fond of saying is that litigation is a game of people, and it's a game of subjective situations. So I try not to paint with too broad of a brush, because a lot of what will be effective as a leverage point in any given case is pretty specific and detailed to that particular case. But if I had to generalize and just give some general advice and information about where pressure can be applied, I would say, first of all, it's very important that the defense understands that we're willing to try a case, and that we're not going to be willing to settle for a compromise settlement that's far off from what we think the case is actually worth. Additionally, I'd say that like being technically competent is very important. Competence is king. If you turn in papers on time with the court, you turn in your pretrial documents timely, they're high quality, you turn in very high quality briefs, you make good arguments, you keep stupid arguments to an absolute minimum if you ever make them. You really try to be as good of a lawyer as you can be on the technical side, take very good depositions. That can be a very big leverage point, because it influences their perception of how trial is likely to go for them. I mean, one of my favorite moments in my whole career was the day I settled probably the biggest case that I've ever settled. I got a text message from defense counsel telling me how great of a job I did and how good the depositions were that I took in the case, and how impressed he was, which was pretty amazing, because number one, you don't really ever expect to get that kind of text message from defense counsel. But number two, in a big case like that one where there was huge exposure, you never really feel like you did a good enough job in the depositions. You always wanted them to go as well as they can. So it's like having the feedback from the other side saying that they were highly impressed by it was a pretty great moment for me, because it validated what I'd been doing. So I think that being a competent lawyer who's not going to advise the client to settle for anything that's not a fair value for the case is very important.
Yeah.
It's like I like to say, in any case, there's a clear yes and a clear no. There's a number that we would clearly accept to settle the case. There's a clear no that we clearly wouldn't accept to settle the case. And those numbers aren't going to be right on top of each other. If I think a case is worth $1.2 million, $1,199,000 may not, or $1,999,999 is not necessarily going to be a clear no. There's usually going to be a range where it's sort of kind of up to the client. But if we get a very clear picture of like, where's no, where's yes, where is there possible room for disagreement, we can give really good advice to our clients about where, what they ought to do whenever they're being confronted with any given offer.
Yeah. Kiernan, it's great advice as always. I appreciate the time and the insights, my friend.
Thank you very much, Mike.
And thank you to everyone out there for listening to this installment of Limits Exhausted, Texas Injury Litigation Podcast. If you want to connect with Kiernan, you want to learn more about his work, do me a favor right now, visit McAlpinelaw.com. Do me one more favor before you go, like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. I am Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.